Hi guys, it's Kathy. I hope you're doing well. So today we learn a secret. Jail calls are recorded, and the prosecution can listen to those, or the police, or other people. If only the inmates were told this in some way before they make stupid jail calls. If only it wasn't a huge secret that there's no way an inmate could ever really know. Oh wait, I think they post it right at the phones, and then they tell them 100 million times. And then we've seen cases, many cases where they use jail calls. So why the heck would an inmate use their jail calls to say stupid stuff? Why? What do they think? They're not going to get recorded? I don't know, but we're going to hear some jail calls today. Here we go.
Just briefly review the facts of the case. We did not have Ms. Johnson come in to testify, as well as Ms. Boots, our domestic violence expert, was unavailable to testify. We were able to admit some evidence, though, corroborating that there was a domestic violence incident or a DV incident taking place, a domestic dispute happening within that home. We could hear the 911 call, Ms. Johnson and Mr. Williams engaging in a verbal argument. We can hear the phone crash to the ground. Officers arrive on the scene and find Mr. Williams about a block away from the home that he was living in with Ms. Johnson, that he was restricted or prohibited from being at pursuant to the protection order that was at issue in this case. That protection order did serve as our underlying crime. And the reason that I think that that's so important here is I think the dispute and the disagreement was whether or not a burglary actually took place. And I think with the evidence that came out in trial, it was clear that Mr. Williams and Ms. Johnson had consented to living together in violation of that protection order. They were residing within that home. I believe in the PSIR, Mr. Williams indicates that he had been living in that home since November of that year, in 2024.
Thank you for the sunshine. I appreciate it.
So I think that is something that is also widely undisputed, but I think what comes down to the big issue is the burglary. And as the law allows, and as the people proved to a jury beyond a reasonable doubt, is that not only was Mr. Williams living in that home in violation of the protection order, but further, that violation of a protection order, the Supreme Court of Colorado has found constitutes a crime against a person or property, because protection orders are always issued when there is a threat or a physical action taken against a victim. So there is always that criminal action of a threat to a person or property, making it a burglary here, as we did prove to the jury. The concern that the people have is that these protection orders are in place to protect victims' homes because the home is a sacred place for people to remain. And the fact that he was living there, whether or not Ms. Johnson was okay with it or not, was prohibited by this court and by the law. And then we hear that there was, in fact, a verbal argument that appeared to escalate to a physical argument as well, based on Mr. Williams' own statements in the PSIR, that bleach was thrown. We did have evidence, should Ms. Johnson had testified, that would have indicated there was a physical altercation as well. I understand that was not evidence the court heard, but I think it was widely undisputed and has been proven that there was that altercation taking place, which is essentially the issue of why we were here and why we were at trial. Is of paramount concern to the people, is that he should not have been in that home for those very reasons, that there was continuing conflict and strife within that relationship and a threat to Ms. Johnson. And clearly she did feel threatened when she called 911 and asked for help, and there was that protection order in place prohibiting him from being there. I would just like to point out a few highlights in the PSIR for the court. I think we've already kind of looked at the defendant's criminal history here, but I would note I'm seeing at least 5 convictions for acts of domestic violence. several felony convictions. I believe this is going to be the defendant's 6th felony conviction. Without belaboring and going through every single charge here, I think we have about 3 pages worth of convictions. The people are extremely concerned about Mr. Williams' continued violations of law over the years. We have ranging from traffic infractions to aggravated felony cases, clear noncompliance across the board. There have been jail sentences, probation sentences, numerous chances on probation, numerous plea deals that were struck in these cases that I think would have achieved, if it was possible, deterrence from committing future crimes and respect and accountability for his actions and for the law. But clearly, Mr. Williams does have a disdain for the law and continues to violate the laws and court orders that have been put in place to protect victims. The people are concerned that we have now exhausted our attempts to promote rehabilitation, to promote that accountability, to promote that respect for the law and deterrence of future crimes. And we are at a point where Mr. Williams is showing clear defiance and aggression towards any help or rehabilitation that has been provided to him. And that's further evidenced later on in the PSIR, where it is detailed all of the different evaluations, treatment, counseling that has been referred to him, made available to him, where he has been aggressive, where he has escalated the situation, where he has been asked to leave or has been discharged unsuccessfully for his anger and aggression towards the evaluators or his non-compliance with treatment in general. That is another concern that the people have, is that not only is he not participating and engaging in the terms of his probation previously, but he's...
Why, thank you, guitar. I love guitars. I appreciate it. Thank you very much.
Actually escalating that and being aggressive and harassing the people that are there to help him. This is no different than the facts that we heard within the case that went to jury trial. And that not only was he taking the law into his own hands and deciding to modify a protection order that was not his to modify, but then further fails to take any accountability, then proceeds to be angry and aggressive during the pretrial conferences or arraignments that we've had, during the jury trial itself, where he was using profane language directed at the people, where he was angry at the verdict and had an outburst in court where he slapped a water bottle towards the direction of the people, was cursing and had to be escorted out, and then turning to the PSIR where he continues to deny that he had any wrongdoing. The only accountability that people are able to discern from this PSIR is that he said he should have gone through the courts to modify that protection order. But there is still a lack of accountability that is concerning to the people, which leads me to, I do have a few jail calls that I would intend.
Just tell him, look, we're not mad, we're just very disappointed. Just tell him that. Try that.
To play for the court that were during and after the trial. If I may do so now, I think I just need to plug in.
Yep.
And Your Honor, if I may approach, I do have copies.
Yes, we did once, but it was firing squad, not hanging. That still counts though, right?
Of sort of the relevant times that these calls are from that are in a log that I can share with defense in the court at this time.
Make sure you share it with defense as well, please.
And Your Honor, before I play these calls, I would just like to note that the court previously did modify the protection order to allow contact between Mr. Williams and Ms. Johnson. At that time, I believe it was just for electronic communication only. However, the people would note that given these calls that were pulled during and after the trial, even though they were allowed contact, these phone calls that were made discussing the case were made from a different inmate's PIN. After they're done discussing the case, they then return to normal contact where Mr. Williams is calling from his own PIN to Ms. Johnson again. The people have concern that these calls were essentially, attempted to be hidden and would be not heard, essentially through these means. But we did listen to these calls. We are very concerned about the communication that was happening about the case, and I do think they're telling for sentencing today. The first call that the people would play is 3-1. That was made on the 9th of December 2025.
And Judge, the defense is objecting to the playing of the phone calls. Mr. Williams was not charged with victim intimidation or harassment, violation, protection order. No charges have come from these contacts. As this court is aware, just like the prosecution and myself, there is often back and forths, I'll say, for lack of a better term, between Ms. Johnson and Mr. Williams. Her lack of appearance and then appears. She makes one statement one day and a different statement the next day. We are not disputing that they have had a tumultuous relationship. I don't think that these calls are relevant to sentencing. The court has the information from trial, the evidence before the court as it relates to these counts. Without him having been charged with anything, I just don't see how they are relevant to sentencing.
Well, so I don't know what I'm going to hear in these phone calls. It sounds like from defense argument that at least it may go towards some sort of intimidation or something like that. I can tell you, first off, I agree there have been no charges, so I won't consider it for that purpose. But if that is going on, that's still relevant towards sentencing as far as what the appropriate sentence is, any rehabilitation concerns, any continued danger. So I still think it's relevant to sentencing, and you can certainly address, well, what you've already previewed, that it may be some on both ends. But I am going to overrule the objection to playing them. What weight, if any, I give these, yet to be determined.
Is calling you from El Paso County Jail. Press 1 for accepting the call. This call may be monitored or recorded.
I'm getting up. I had to email the company, the GSP, all that, because whoever that officer is or whoever that shut down that thing, I think they shut down me even loading money to be able for you to call me.
That's crazy, for real.
Every time I try to load money on there, whether it's from your card or my card, it red flags the screen and says, error, contact IT. They won't even let me put money on my fucking phone.
Wow.
So I was pissed off all day.
Did you contact IT? Just asking.
Fucking yesterday, so I was trying to put money and shit on the phone so you can call tomorrow and tell them happy birthday.
I know, listen, I stayed in trial all the way to 6 o'clock. My trials lasted all the way to 6 o'clock. They lasted all the way to 6 o'clock. I get there at 8 o'clock, 8:30. They last all the way to 6 o'clock. Yesterday we stayed, I didn't get here to 6 o'clock. I didn't get back by 6:30.
Jesus.
Yeah, so I gotta go back today. And Miller said it won't be back, but we on their ass like they're not using no statements or testimonies of what you gave or what I gave, basically. So they dropped the assault charges and all of that type of shit. So these bitches taking me to court on burglary, violation of protection order, and obstruction of phone. Savannah is lighting their ass up. The police has been all over our side. Now I'm gonna beat that burglary.
You have 3 minutes remaining on this call.
I'm gonna beat that burglary shit, but they still gonna probably find me guilty of the violation of protection order. Something that I've been telling them I've been guilty for from day one.
Well, that's fine, babe, because you've already been in jail for a year.
I know, but I'm just saying that like this is the stupid shit of what they did. Man, these bitches is standing up here making themselves look so stupid.
That's what they are.
Ain't nothing that the officers say. This man ain't tried to run. He didn't do nothing. They got into an argument. They started trying to make these folks feel like, oh, it was a domestics in these places, and the officers kept saying we were responding to an argument of a house call that was from a woman, that was from a husband and wife argument, not no violence. So Savannah is eating their ass alive.
Come here, Capote.
So that's basically what's going on. I just wanted to tell you because I know you probably were wondering why I had called. Because yesterday we came out at like this morning. They got us out from 6 to 10. So when I come back, I'm not gonna be able to call you till tomorrow night, Wednesday. It's 7 o'clock. We're not gonna have court tomorrow. They're gonna dismiss. Mr. Miller gave us a time off for tomorrow. So we're gonna have court again Thursday. So hopefully he throw that shit away because they said by halftime or something he's supposed to be dismissing the shit. I don't know. You know what I'm saying? But I just feel like I feel like he's not gonna. I'm not gonna get around the stay away orders, but the rest of the shit, the burglary shit, all of that, I am.
And that's fine. Because
Your call will end in 1 minute.
I mean, on camera, they're using the body camera, telling me, you know, saying that, hey, he did this and I did it. And like the jury said, we have 10 men, we have 11 men jury and 2 women. Miss Savannah picked a 10 men jury. She said, we're not going to have no woman jury because this is not a domestic violence. You know what I'm saying? So she picked a men jury. But before the phone hang up, I just want to tell you I love you, and I try to call you when I come back tonight.
I love you too. I was waiting to hear from you. When I say, like, Tristan has been harassing me, like, stalking me, calling me from different numbers, like, non-stop.
Yeah, that's what a bitch had to do.
Leaving me messages, telling Callie how he's gonna fuck you up now, and you better watch it. Just all this shit, like...
Man, tell that shit go suck a dick. You tell her, say, your husband,
it's like she's misplacing her anger. She needs to be mad at that nigga because he's trying to buy my bitches and want to fuck.
And the next call that we would be playing for the court is 316-141-834. And this was placed on December 11th of 2025, 2 days after the trial.
Hello. Is calling you from
El Paso County Jail.
press 1 for accepting the call. This call may be monitored or recorded.
Hello. I couldn't answer yesterday because the people was out here.
Oh.
Just going through, making sure everything was done, and for a few other reasons. But what's going on, babe?
They found me guilty.
Of what? Burglary.
Yeah.
The reason why they're confused that they found him guilty of burglary is because he had a protection order in place. He wasn't allowed to be at that address, okay? But he actually lived at that address still. He never left. He always lived there. So they got into a fight one night. She called the police. They arrested him. They charged him with burglary. I don't know why, and it worked.
And how are you guilty of burglary?
Well, the jury found me guilty. They played the phone call where you were saying, get out, and they saying that by the possession order saying that I wasn't supposed to be there, and I know that carries an account for burglary.
Okay, we were in an argument saying get out, you didn't break in.
But that's why I cussed my lawyer out. I snapped in that courtroom. I cussed her. I called her all type of motherfucking bitches in there because the thing is, you told this girl not to even come. You've come into court. You told this girl not to goddamn come to court. And them folks played that goddamn phone call. And the phone call that they played made it seem like I entered their house and you was telling me to get out. That phone call to that police they played took me all the way down through there. When the jury heard that, them folks were looking crazy at me. I know then that them folks were finna find me guilty. That phone call they played when we were arguing on that phone and you was telling me.
So why would she tell me not to come?
I don't know. I don't know.
When is the next date?
They not sentencing. I don't have court date no more. They found me guilty and I don't have sentencing to January 28th.
From this phone call right here, the prosecutor is saying that he threatened his lawyer. So listen, pay attention and see if you think so.
I cussed her out so bad. I said, man, you told her not to fucking call me. they found me guilty, so I don't know what them folks gonna give me.
I'm going to have to make it into Judge Miller. I'm just going to go in there and I'm going to let him know.
They came,
I'm trying to stay so calm at work right now.
They was trying to habitualize me, and they convictualized me because the jury said there wasn't no violence. We know they was not fighting there. We know all of that. But the way them goddamn folks, and I was so mad at this lady because, bitch, the way them folks broke that shit down, they didn't find me guilty or saying that I kicked in a door or something like that. They broke that shit down to these folks like in a dictionary word of what it was. He knowingly knew that he wasn't supposed to be there, and they played that thing when you were saying, get out, I'm tired of this, get out. Then they were saying I wasn't supposed to be in that residence, so that was a violation of the protection order. Plus, I knowingly knew this, so they made that as a burglary, and they said that, man, by the dictionary word, not of the actions of what happened, but by the dictionary word, and then they this bitch didn't have none of the fucking, then the bitch, that bitch Miss Parker gonna say, but, and then you see if she wanted him there, she didn't even try to get it modified. They told that lady that she couldn't even put in her modification statement. Everything just went completely wrong that last day, man. Everything just went completely wrong. Everything that was wrong that last day, the folks came back and found me guilty, man. I slapped the goddamn word thing off the goddamn tape. The guards came and got me. That's gonna get me out of this courtroom. Don't get me out of this courtroom. I ain't no bump.
Yeah, and her investigator made it seem like it was a good thing for me not to go.
That's what I'm saying, and man, that was the worst thing in my life, bro. That bitch, I said, man, why y'all didn't told my wife not to come to this courtroom? She said that she wasn't gonna come anyway. She wasn't gonna come. Man, I like to flip that goddamn table, man. That lady got me found.
No, it was because they kept insinuating that without me going to say anything, what would they have? That's why.
Them folks motherfucker had that motherfucking phone call. That's what they had. They had the phone calls of you saying, get out. And they made that to the point where I entered that house or anytime, I didn't even have to enter as long as I...
So what you're saying is you should be careful of what you say on phone calls because the police might be listening? Is that what you're saying out loud right now, sir? Sorry.
Was there and you was telling me to get the fuck out of that house. That's what made it a fucking burglary and a violation of the protection order.
Okay, so I am going to, tomorrow's my day off, I'm going to go in and I am going to request for Miller. I'm going to say at the time, when we were in that argument, one, he was already living there, but I'm going to write it specifically to him and say, me telling him to get out was about seeing something in his phone, not because anything else. I did not want to see his face because of what I just found. That's what that was about.
Man, those folks motherfucking goddamn found me straight guilty, man. So this shit carries 4 to 12 years, man. And they tried to, and they was trying to hit me on a habitual meaning they could aggravate
habitual offender.
And they couldn't do it because the jury said there wasn't no violence, in there. So it's gonna be not a crime of violence. It's not gonna be I guess it ain't gonna be about, but the thing is that shit's still very important. And the way I acted in that motherfucker, man, that man probably gonna give me about 8 to 10 years, man.
No. Judge Miller's not. Judge Miller knows why you responded the way you did. Trust me, he's understanding of a lot of our outbursts.
Man, them motherfuckers put me straight in the hole. Them motherfuckers put me
and
straight in the hole. And
it's going to be up to Judge Miller. He's going to be the one that can decide. A judge can go less and say, due to the facts, and we know that this was, I'm not going to give him. Judge Miller, it doesn't matter what that carries. I've seen plenty of niggas go into the courtroom and something carries a certain, and the judge is like, well, given the circumstance and how it, instead of this fix, I'm going to get into, I've seen it happen, but it's still more the point. Why would they make it seem like me not going was the best idea?
That's what I said, man. That is the worst thing. And that's why I was telling them folks, they say I need to do some shit of something, counsel or something like that. And I'm saying I was telling the police, and they told my wife not to come. She told my wife not to come, man. That was the worst thing ever that them folks could have did. That's why them people were so happy or like, okay, well, we good. We glad she won't come because this is why we're going to explain it, man. Man, it was times where I was just wishing I could have just ran back out and called you. Something in my heart told me early that morning, just to tell you, babe, come to court. Just come to court.
Well, I wish you would have if you would have felt that, because I'm thinking that
I thought it was made the way.
It under control.
That's what I thought made the fucking investigator, man. He didn't come to nothing but one of my courts, and he was there for 1 hour, and they was going, man, this shit went straight left field.
It makes me question her and her motives.
Yeah, that shit went left field. I'm talking about. She was not, even the guards told me, say, that second day, that bitch was not ready. The first day she did good, babe. The second day, it's like Miss Parker and them turned around and just went the same shit that was just plain out saying, I'm finna get found guilty. Like, I'm talking about, and that bitch did not have no pushback. So what them folks said, like, that video, not that video, but that goddamn phone call fucked me all the way up, man. That phone call, them ladies was just, they kept on playing it for the jury. When you kept on saying, get out, I'm tired of this, and they kept on saying, you see, she didn't even want him in the house. She didn't even, and they just kept playing that, and that guilty stuck in them folks' mind. I knew.
Well, good. So when I write Miller, I'm going to be very specific. Me sitting there in that moment saying, I don't want to see someone's face because of something I discovered has nothing to do with anything other than just that. If there's moments in my life where I tell even Envy that, or I told the children that. Get out of my face. I don't want to see you. Get out. Like that's how I am.
I thought that I was gonna have nothing, but I asked this man yesterday. He was like, "Man, you don't go back into Mr. Miller courtroom for sentencing all the way January the 28th." I was like, man, this, because I didn't even hear the last part of it, because I told them to keep me out of the courtroom because I was going to snap. I was like, man, keep me out of the courtroom, man. Just keep me out of here, man. And
to me, it just seems like a setup, like that they knew exactly what they were doing, and I'm thinking, okay, so then I don't, because not going to work wasn't the issue. It's not like nothing stopped me from going besides them putting it in my head that, well, you know, if you're not there, they're not going to be able to.
That's the worst thing. That was the worst idea ever that them folk could have ever did, would contact you and told you not to come. That was the worst. That was the worst thing ever, man.
Yeah, and they kept hinting around it like, well, I mean, if you're not there, and it's just
damn folks, that was the whole DA's theory for you not to be there. That's why they never contacted you, because they really didn't want you to be there. They really didn't want you to be there. That's the only reason they figured. They was like, oh, we don't contact her. We don't want her to come there anyway, because we got these points on these phone calls right here where if she says anything that can destroy our case, and the phone call what she played, they needed you to be there to explain why you were saying that, and you wasn't there, and that's what they found me guilty on. They found me guilty on that phone call, but they found me guilty of a definition of what they said, not of what happened before. A goddamn definition of what a fucking third-degree burglary was. A person, and the only thing on there is here, a person knowing that he wasn't supposed to be inside of that house. I'm like, what? And in our form and in our mind, that's not no goddamn burglary.
No.
That's not a burglary at all. And they found me guilty of it. So that's just like if what one of y'all saying, if I normally would have been in the car with her, and inside of the car with her, and she called, or we got into an argument, what are y'all saying? Y'all would have gave me a theft by taking of a car because I was inside of the car with her?
Right.
You see what I'm saying? But this is because I normally knew I wasn't supposed to be around her in this goddamn car. So what are y'all saying? Y'all would have gave me a theft by taking or something because I'm in the car with her? y'all gave me a burglary charge because I was in the house with my kids. They even brought up Evie name, and so she was like, Evie was in the house. She was like, he was in the house, Your Honor, with his child and his wife. She was like, oh, who? It's no collection that says that is his child. That is what Miss Parker said. Hey, boy, I like the motherfucker that bitch would have been pregnant. I like
Because you guys have different last names, but that's neither here. But that just shows you how ignorant she is.
Man, man.
You have 3 minutes remaining on this call.
And if I was there, I probably would have slapped the shit out that
I
bitch.
know
and
it just went all wrong. It's that last day just went all wrong, babe. Like everybody in the courtroom, even the fucking this sheriff that was in there, they say, man, she fumbled that ball. They was like, man, she fumbled the ball all the way. They ate that bitch alive. They ate her alive, baby, and they kept playing that goddamn phone call. They kept playing that phone call, and they kept reading just the definition and ate her fucking alive in there, man. And I was so mad because I was.
And why wouldn't she take statements of it was an argument based off phone? So regardless.
No, because this bitch went out there, babe, some type of way and made a fucking agreement with these folks that they wasn't using nothing that you say. If none of your statements was allowed in the courtroom, nothing, because you was not there. So the statements what you vote on my behalf didn't even count. Didn't even count.
You can't use my statements, but you can use a recording a call. You could, like, that's what I'm saying.
They went out there and they went in there and made some type of agreement there because you wasn't there to testify. There ain't nothing that you told them, the police or the judge or nobody, bro, they counted on my behalf. Nothing.
Okay. I have some things that I need to file because, I mean, I get a definition's a definition, but when you hear robbery, you think of people that come in, they're taking it, like not someone that's sitting in a living room and just made love the night before. That doesn't seem like a robbery to me. But,
yeah.
Wow.
Yeah.
Like, that just makes me want.
Not me. When I hear robbery, burglary, I think of my family.
Your call will end in 1 minute.
Well, I was going to tell you too, on the visiting thing, right?
Mm-hmm.
We had it under Tavi name, right? So you probably can be able to make one of yours, and that's going to bring that back to your memory. You probably can make another visiting thing. But I only can stay out in this dorm for 2 hours, so I probably be lucky.
Why? Because of what happened in the court, you're in a sort of.
Yeah. Yeah.
What did Miller say when that happened?
They just removed me out of the courtroom and put me in the hole. So I'm in the hole now.
Okay.
The phone finna cut off though. I love it. My roommate let me use the phone thing.
And then the last call, apologies for the length, is 316-156-076, and that is
Okay, I did hear in the last one the wife say, I'm going to slap the shit out of, the lawyer. But he never said that. So I don't know where they got that he was threatening the lawyer. Maybe I missed something when I was going down to get my pizza.
significantly shorter than this past call. Can you repeat?
Hello. Is calling you from?
Sorry, just to repeat that for defense, 316-156-076, and that was made on December 11th of 2025 as well.
The full 8-minute call?
Yes.
El Paso County Jail.
Press 1 for. This call may be monitored or recorded.
Yeah, I just can't even focus at work. I'm so frustrated right now.
Yeah.
It just doesn't make any fucking sense to me.
Yeah, I know. It doesn't make no sense. Like I said, it didn't make no sense to nobody. And this is just. It was like it made no sense for you. It's like when they found out that the investigator lady wasn't gonna show up. I don't know what the fuck in this bitch Savannah mind. I don't know what the fuck her thoughts was, babe. But this bitch thought was they was making this out of a DV case, and they wasn't making it out of a DV case. You see what I'm saying?
Mm-hmm.
They didn't make it out of no DV case. I don't understand what that bitch thought in her mind. Ain't nothing in there where they said that I tried to touch you or do any, nothing.
You didn't.
I know, but they didn't make that, and I don't know what type of shit that this bitch had in her mind that they was going out there. But
they knew she was a stupid bitch that they could play like a fiddle, so they did.
Played that motherfucker like a fiddle.
And they probably, I'm telling you, because there's no way that as your attorney should have been like, you know what? I know sometimes people don't want to show up, but you should show up. You guys are making it sound like it's going to be best. I don't know. I'm just at work pissed. I'm running into shit.
Not even, and it wasn't even about that. They played her like a straight fiddle. Even the guards and everybody said that when they was in there the last round, they said they played her like a goddamn fiddle.
And I was just talking to Emily, like I had to call my baby, and I didn't want to stress her out, but it's like I'm gonna have to talk to her about this, help her brain understand. I'm like on fire right now.
Yeah, baby.
And I'm trying not to let it take me to 1,000 because I know that there's plenty of people that are found guilty, and when they get in front of the judge, it is Judge Miller. You're not being sentenced by jury, you're being sentenced by the judge. And so, Miller could be like, I know that we're looking at it this way, but I know the facts are he's already there. They got into an argument about this, so it's not the same as if he popped up. So I'm not going to.
They didn't. Okay, if they would have found it guilty, they would have found they found me guilty on the burglary, and they found me guilty for the violation of the protection order, right? Something there.
Maybe because you were guilty of your protection order, but let me just try to give you guys a hint of how often I get pizza. Okay, so I made it a rule a bit ago. So there's 3 adults that live in this house, me and my 2 children. Anthony is 22 and Tiffany is 25. Well, okay, I said, you know what? I will do 3 nights a week, dinner 3 nights a week, and each of you will do dinner 2 nights a week. All right? I don't care what you do. Don't ask me what I'm in the mood for. You figure it out. You get dinner. Okay? And now I don't cook every single of my 3. I'm not going to tell you I always cook. Sometimes we go out. But I cook often. They absolutely never cook. I don't care. Their job is just to make sure that we have something to eat in the house on that night. So you can guess off of that how often I eat pizza for dinner. It's freaking often, and I'm sick of it a little bit, but it's still pizza.
All those knew that I already had to plead guilty to, right?
Mm-hmm.
Okay. They didn't find a cause of violence on none of them, meaning that they didn't find a domestic nowhere around me, so they couldn't officialize me.
Yeah.
So they sitting there saying that it wasn't no violence, no violence take place in their home.
Correct.
That's facts. That's true.
Yes.
I understand that, but it was the sensible thing of how they put up on that screen and how when they played that 911 call, right, and how they just kept on saying the definition of what a burglary charge was. They didn't find me for a crime that I committed. They found me guilty for the definition of what a burglary was. And they put those 2 together and stacked that upon me. You see what I'm saying? So when they played that,
go jump in. I'll tell her.
So when they played that phone call, that bitch didn't have no fight power or no type of statement to go back up there and say, okay, well, this phone call wasn't about this right here because she agreed not to use your statement. You see what I'm saying? This stupid bitch, they play her so stupid. They knew that investigator lady, not investigator lady, but the DV lady, right? They knew that the DV lady wasn't gonna be there, right?
Yeah.
So for the DV lady not to be there, she's like, oh yes. She came back and said, well, the DV lady is not gonna be there. I'm looking like, I don't give a fuck if the DV lady was here or not testifying. That don't mean a motherfucking thing. That means, you know what I'm saying? But then she said, well, we agreed not to use none of her statements. So I just looked at her like, so you telling me the statement with my wife to sit here and told them that I didn't do anything, it's not going to be read or heard? Babe, this bitch didn't have...
And why wouldn't she call me and tell me that if I did not, that was what they agreed to? Like, you know what I'm saying?
I don't know, babe. Like, that was talking them whole thing. When they knew before court that DV lady wasn't going to be there, that lady was out sick, that she wasn't going to be in court, point blank period, they went out there and finessed that stupid ass bitch to agree to their terms, and that's exactly what they did. They finessed her all the way. They let her won the first.
And how is she gonna agree to terms without speaking to you?
I don't know, babe. That bitch came back and set aside this motherfucker.
I'm on fire up in this motherfucker right now.
She just came back and just told me, and I just, me, I didn't know nothing about being in trial. This is my first trial, so I'm just at a state of shock. Like, okay. Like, what do you mean? And so, like I told you, the first day was good. Like, okay, that the police didn't say, it was no violent, nothing. So that was good. But that second day, them bitches left up out of there. That bitch probably didn't even go home and study nothing. That bitch went home and went to sleep. Them bitches went home and set up a whole nother plan because she ate them up that first day, baby. They whole plan of getting the police on their side and all of that, they did that second day. Them bitches went back and regrouped and talking to them, claiming them with some goddamn with that goddamn motherfucking phone call, and they wouldn't point shit out, and that bitch she did not have no comeback with what them folks were saying. You know what I'm saying? And I'm like, why did you not tell my wife not to come to court on this statement right here? Why are they allowed to play that phone call? That phone call, when they kept on saying them, Mr. Parker, and saying, you hear her telling him to get out. She do not want him there. She didn't want him there. See, you hear this, right? You hear this. So that shows you that in the definition of burglary, knowingly not wanted in a residence.
But it's different. It because it's about abroad on the phone.
That's where everything went wrong there, because that bitch agreed, because that punk ass bitch, they agreed not to motherfucking use your testimony or you not to come to court, babe. What we got to do? What?
Just so you know, I deleted hundreds of words from his calls. Just one word specifically I deleted hundreds of times and left all the rest in.
Hey, we got a lockdown, so they gotta let one of these put.
And I think the call glitched at the very end. I was just hoping to play the
Hello.
first 30 seconds.
Hello. Is calling you?
Niggas out. They can't be
Just
round.
relax. Just relax.
This shit be killing me, man. These pussy ass to be doing all these charges and get caught with all this shit, but this pussy ass needs to got a fucking say where he can't walk around. He's some hoe ass, bitch ass, man. I can't stand these fuck ass, man. They do all of this burglary, all of these crimes, and they can't even come. They got face. Man, babe, I love you, babe. We come out tomorrow. What time we come out tomorrow? At 7 in the morning? Yeah, 7 in the morning, babe.
Okay.
I'll try to call you. I love you.
Love you, babe.
Great, bye.
Your Honor, these calls are concerning to the people in a variety of reasons. Of course, the court is aware that Ms. Johnson was not present for trial. It appears that she and the defendant were colluding in some form or fashion for her not to be here. It is the people's belief that when Ms. Johnson didn't appear for trial, it was their assumption that the case was going to be dismissed. We did try to have her personally served. We did try to communicate with her. She was choosing not to participate at that point in time. We have since talked with her, and I do have concerns for her safety. The court is very familiar with the cycle of domestic violence and how that can impact a victim and how it ebbs and flows in a relationship. And I do think that that is what's taking place here. I think that Ms. Johnson is acting out of her own best interest to keep herself safe, but I have immense concerns for the defendant's continuous display of violations of law, of anger, and of violence towards his intimate partners. I think it's evidenced by his criminal history. And I think with what we were able to put forward in the facts of this case, it's evidence there as well that he doesn't have any regard for the law or for court order, and that he is going to do what he wants to do, and he's going to be around who he wants to be around. There was a dispute that day. There was clearly violence and threat of violence in the deferred sentence for the stalking case against Ms. Johnson as well. The people are...
A lot of people I know, like... They use that sink full of sunny water, and then they scrub off the dish and pull it out and then put it in the they put it to dry, and the suds are just running down, and I cannot. After seeing that so many times from people, I went over to their houses. I can't. I run water. I make sure there's no suds anywhere, not even on my hand. I put the dish over.
Are concerned that he has had every opportunity here to rehabilitate himself or deter him from future domestic violence allegations or violations of law in general, and he has not done that. I think.
And then before I cook, I wash it. I wash it again, just in case.
That these calls are a clear display of no remorse, no accountability, and blaming everybody else for his actions on that day. He blames his own attorney, he blames us, he blames the court, he blames the victim, he blames the 911 call, he blames the dictionary definition of burglary, but he doesn't take accountability for the fact that he should not have been there on that day, and he should not have been violating the protection order and in that home at that time. I think given all of the concerns that the people have, we are asking for a maximum term of 12 years in the Department of Corrections in this case, to be served consecutively with 3 years for the revocation of the stalking case. I have immense concerns about his recidivism, and at this point, I think a harsh Department of Corrections sentence is really the only thing that is going to get through to Mr. Williams and keep our community safe, prevent any future violations, domestic violence or otherwise, and hopefully deter any future crimes when he is released. I think that a Department of the Corrections sentence is appropriate here, given not only the allegations that, while I understand it might appear to be a technical violation,
Technical violation? No, it's not. He was living there. How is that a technical violation? Anyway, because it's not but it is a new crime. It is a new crime. That's actually a criminal act, because he's not allowed to do that. Michael, he does not need soap for his mouth. What he needs is Bobby to cook him something.
it's so much more than that. And coupled with his criminal history is extremely aggravated. And I would also make a record that while there is no restitution immediately associated with this case, we have spoke with Ms. Johnson, and she is applying for victims' compensation for this case. So we would be asking that it remain open for 63 days. We just don't have any final costs or losses at this point in time. I'm happy to answer any other questions the court may have.
I don't think any right now. Thank you. Let's start where the DA left off first. Let's just talk about restitution briefly. And here's, I guess, what I need to say about that. So, Mr. Williams, I'm going to order that you pay restitution. You're welcome to stand or sit if you need to. I'm going to order that you pay restitution as part of this case. We don't know that amount yet. Okay, so the people have 63 days to determine what amount, if any, and they could end up saying zero, right? Or some amount.
Thank you for the
just so you're aware, I'm going to sign off on that right away, but your attorney's going to get a copy of it as well. And if she believes there was an error in calculating that, she can get you back here for a hearing on that, okay? But I want to be clear, I'm ordering you pay restitution as part of this sentence. We just don't know what that amount is going to be yet, okay? And it'll be somewhere between zero and whatever they end up requesting. we'll sort that out with a hearing if we need to. Okay. All right. Then I will take defense argument.
Okay, you're good. So Judge, just after me. Yeah, he was asking when he can go. I was like,
You get the last word, sir.
yeah. So Judge, I'm going to start first by addressing the phone calls and then proceed into our statement as well as some of the newer evidence that the defense has received since trial. So I'm going to start first with call number 1. In this call, you can hear that, yes, Mr. Williams feels very strongly about the statute. That is also reflected in call number 2, when Mr. Williams is continually discussing the definition. That is a lay person trying to explain a statute. What's not seen on this is the conversations me and my client are having at the same time, where we're discussing what is burglary under Colorado law, what is this definition. Because I do think it is relevant to kind of
Can I get you a cup of coffee?
the argument that we're making today, I also want to put on the record that no statement made by me nor my client is intended to waive the potential appellate issue related to the Walhoff case that we filed. I am going to address some of the protection order definitions and statute in light of the conviction, while still maintaining that we believe that there is some sort of error in how the charging documents were done. But I think it's especially relevant to address that now in light of the phone calls. So what's not played in the phone calls and what's not clear and what's assumed by the prosecution is that Mr. Williams having conversations with his wife at the time about how trial went. The second and third calls are after trial. He's already been convicted. He is going to give a brief statement to the court regarding how he responded to the conviction. So I will leave that to him to address. But I don't necessarily disagree with Mr. Williams on how he feels about that statute. It has caused a lot of strife and grief for him. And his language may not be the same language that I use or the same language the prosecution uses. He may curse and describe things in a colorful way, but that is how he talks. That's how he talks in our visits. That's how Mr. Williams expresses himself. You can hear him crying in one of the calls. He is very upset in the third call. He was very upset with the verdict. I think we were both upset with the verdict. But what you don't hear in any of the calls played by the prosecution, nor in any of the text messages that I will discuss in my kind of initial arguments, not response, does Mr. Williams ever say, I'm going to hurt you, I'm going to kill you, I'm going to come for you, I'm going to hurt your kids. Nothing like that ever leaves Mr. Williams' mouth. I've read hundreds of text messages, maybe not hundreds, but a lot of text messages between him, Miss Johnson, I keep saying Miss Williams, but Miss Johnson, as well as other significant others of Mr. Williams. And he is colorful and he is flamboyant. And he was very upset with the verdict. And so when we look at call number 2, what Mr. Williams is trying to explain is the subpoena power of the defense. Part of the strategy that we discussed at length was whether or not we, the defense, would subpoena Ms. Johnson. And that is a discussion I have with my clients, right? If she shows, if she doesn't show, should we subpoena her? What is confrontation? Do we waive confrontation? What Mr. Williams is describing to Ms. Johnson is his understanding and explanation of how trial is going, how things have went. It is, in my opinion, a conversation between a husband and a wife who are in what is clearly a very toxic relationship and maybe are not right for each other. That is discussions me and Mr. Williams had, but he's not threatening her. He's not saying, let's go back in time and change things. He's saying, this is what happened. This is what we went through. Him and I discussed trial the exact same way, but with the legal terms. So instead of definition, we would talk about statute. Instead of should she come or not come, should we subpoena, should we not subpoena? That's what these calls are after he's been convicted. The third call, where Mr. Williams does get upset towards the end, leading up to that call, you can hear his voice breaking as the call goes on. Miss Johnson makes a couple of statements that I think are highly important. And so I don't object to the final call. I will withdraw my objection to that call being played as sentencing, because since the beginning of this case, both Miss Johnson and Mr. Williams have maintained, and from Miss Williams' mouth of her own volition, that she threw bleach on him because of the broad on his phone. And so I want to stop there, because all of this came from what Miss Johnson has told.
And that should be legal. We should sign a petition.
The DA's investigators, what Miss Johnson told my investigator, what my client told me, is she went through his phone and there was a woman on his phone and she got mad. On that call, she says, it's about a broad on the phone. And I wanted to stop there, because after that statement is made again by Ms. Johnson, which is in our belief the truth, he does get upset again. And I think him being able to wrap his mind around it maybe isn't the healthiest way or the most appropriate way. But this is right after being convicted of a charge that still to this day we talk about when we visit, the definition of burglary, how we get here. And so I strongly disagree with the prosecution. I've listened to the calls. I've now listened to them again. When I heard them, I don't feel like he was threatening me. I think he was expressing himself about trial. I didn't find anything in the calls to be concerning towards me, towards the prosecution. I heard a person discussing, who's not a lawyer, with another non-lawyer, how trial went.
Oh, wait, you have.
So that's all I'm going to say about the calls. I want to highlight a couple of things for the court in response to the prosecution statement that I think kind of is different than how the facts have been presented, but I don't want to spend too much time on it. First, I would note that Mr. Williams spent approximately 22 months on probation without any incidents. The 24M case that kind of snowballed into where we are today was ultimately dismissed. The protection order that existed in the 24M case, there had been attempts by both Mr. Williams and his prior counsel, as well as Ms. Johnson of her own accord, to modify that protection order. One of the things that really upset Mr. Williams and ultimately was sustained by the court was the statement that the prosecution made in closing arguments that there was no attempt to modify the protection order. The defense objected at that moment. The court sustained it.
I'll die.
It's something that him and I have talked about since then, because he feels like it did impact the jury's decision-making. Ultimately, we did choose not to subpoena her. We did choose not to call her as a witness and waive confrontation strategically, but he's allowed to be upset with how the trial went, and he's allowed to express himself in a conversation. That is not to say he's threatening her or anything. It's him explaining the trial. Up until that point, though, there was 22 months of compliance on probation. Ultimately, the case that started was dismissed. Ms. Johnson did not cooperate a few weeks ago. The trial did not go. It was dismissed and sealed with prejudice, and it leaves us with this case. The other significant thing that happened after those 22 months of probation was there was a shift in probation officers between the probation officer that needed to do the certain evaluations and his original probation officer. The first probation officer, the first probation officer in both minute orders that I have been able to access and proceedings that I have reviewed, Mr. Jacobiak, indicated that he was doing well on probation and that he should probably not be with Ms. Johnson, and that Ms. Johnson does cause issues in his life. This court, I think, as I stated earlier, is more familiar with these proceedings than any of us because of the length of time that Your Honor has been on the cases, and has seen the back and forth that Ms. Johnson kind of presents as. I can tell the court that I've never spoken to Ms. Johnson. I've had my investigators do all interviews with her. And ultimately, at the end of the day, strategically, we didn't call her as a witness or subpoena her. At the end of all of this, we get to the actual trial. I'm not going to rehash what happened at trial. I think the court is very familiar with the facts. You were there. I think the 911 call ultimately is something that was very upsetting to Mr. Williams, but ultimately Mr. Williams was found not guilty of telephone obstruction. He's never been charged with intimidating Ms. Johnson. He's never been charged with threatening her. I don't have any text messages or records from the jail released to me where he has done that. But what I do have is in March, Mr. Williams and I discussed it. Mr. Williams ultimately texted through the app that he was cutting off his Social Security checks and power of attorney to her, and that he had notified the Social Security Administration that he was no longer going to allow her to have access to his money.
I think of him when I drink a beer. You think of him when you eat dessert?
After that text message is sent out, he texts her that he would, in his language, stay TF. I can assume the court knows what that means. Away from me, leave me alone. After that, there are repeated calls from Ms. Johnson to Mr. Williams that he does not accept, that he does not answer. She proceeds to video call him again, all the way up until I receive a message from my investigator that now she has decided to make a new statement, all the way up until a report I received today that once again, Ms. Johnson is making yet another new statement, and this time indicates that my client has threatened me, which has never happened, indicating that my client has directly threatened the prosecution, which has never happened, and that he has threatened her children, her boyfriend, herself. None of that has happened. And so I think that's important to highlight because we are dealing with someone who one day is, let's modify the protection order, come home, and the next is not. As it relates to the defense's request, ultimately, Judge, I have spent a significant amount of time discussing the cases with Mr. Williams. We considered rescreening for community corrections. As the court's aware, we considered requesting a new PSIR. Ultimately, Mr. Williams chose to take accountability without waiving any appellate issues, but take accountability and proceed to sentencing today. That's why we requested it last week, as opposed to going through and requesting a new PSIR or community correction screen in light of the errors. The defense is requesting that in light of him wanting to take accountability, that he be sentenced to 4 years in the Department of Corrections. Importantly, this request recognizes that Mr. Williams has begun to kind of accept that Ms. Johnson and him are not compatible, that the statutes here are different than they are in Mississippi, and that he should not have been there. Since the first incident in the body-worn camera, he says, I know I wasn't supposed to be there. And one thing that the prosecution did get right is that, yes, he was living in the house. He has been straightforward about that from the beginning. And he does take accountability for that. But what Mr. Williams was not convicted of, and what I think is important, is he wasn't convicted of entering some unknown residence with some violent intention. He was living there. He was paying rent there. Was that against the court order? Yes. And that is why we are requesting a 4-year sentence and not the minimum, because he does take accountability for that choice. And ultimately, he knows he shouldn't have been there. Secondly, Judge, I think it's important to note that Mr. Williams' priors, while they exist, are before meeting Ms. Johnson, about a decade old. Before that, and before Ms. Johnson, there was no real issues here in Colorado Springs or even in Mississippi. He was on that deferred sentence. I did not represent him on that case. I know the facts loosely. Ultimately, he took a plea in that. And we are asking that the conviction that will enter based on the revocation of there being a new conviction, the deferred would revoke. We did not call probation as a witness for bifurcation issues. We're asking that that F5 stalking be concurrent in 23 CR 1169, that he be sentenced to 4 years. At the end of the day, Judge, Ms. Johnson's credibility and level of cooperation has been a reoccurring issue throughout all of his proceedings. There are times she would respond to us as the investigation team. There were times she wouldn't, all the way up until today. She's meeting with the DA and doesn't appear in court. And so I asked the court to look at Mr. Williams and the actual facts of what happened and the knowledge that this court has, and sentence him in accordance with that and not punish him for allegations that have not been proven. Don't punish him for things that are said that are not true, such as threatening his attorney. He's never threatened me. All of these things are assumptions by the prosecution, and I asked the court not to consider them when making its determination as to sentence. I think ultimately, at the end of the day, both the defense team and Mr. Williams were upset about the verdict and still maintain that there is an issue with the burglary conviction as it relates to the legality of it. That is maybe expressed differently from Mr. Williams when he's on the phone with her after trial, but ultimately he has always taken accountability that he should have gone through the courts. He tells the police that the day he's arrested, and I think he would do fine on probation if he was not married to Miss Johnson. I think he would do fine on probation if he was sentenced to probation. But at the end of the day, we are asking for 4 years in the Department of Corrections. I know he wants to make a statement to the court as well.
Right, 1 second before I hear from him. I neglected to mention that probation is here as well, and I didn't know if probation had a statement you wanted to make with respect to sentencing or not.
Would the court like my statement at this time, or?
If you want to make a statement, yes, I want to take yours now. I'll let you respond to anything probation says, and then again, Mr. Williams, you get to go last.
I would disagree that Mr. Williams was confined on probation. We could look at the PSIR pages 11 through 14, or I believe 14. Those are my statements on how he did while he was on probation. We provided him referrals to Gateway to Success. He missed 5 appointments to do a PSI. Finally got that done. He was agitated, aggressive in those appointments, threatening. He made threats to other therapists. He was kicked out of DV treatment for aggressive behavior. He was doing mental health medication treatment, made threats to an RN there, Finally, the program director just said, we're not providing Mr. Williams any services. We've had the same issues in my appointment. I've reviewed narratives with his other 2 POs where he was finger pointing, supervisors had to step in. So Mr. Williams hasn't done well on probation. I think probation isn't appropriate for him. So that's what I would have to say.
All right, thank you. Ms. Fox, you first in case you wanted to respond to anything probation said, but if not, I will hear from your client now.
Judge, just briefly, I would note that the kind of incidents and allegations that probation highlights are after the switch in probation officer related to the PSE and the evaluations that were ordered by the court. I have been through records from Diversis and things like that. I don't have any kind of information that substantiates any issues with Diversis. I know that he does have, there were some instances during the PSE that he would get very riled up in. But again, those are after the switch in probation. The initial probation officer and the first portion of probation, I think, was a very different version. I think involving that different type of evaluation did have an impact on how
We get to hear from him soon.
he was progressing on probation.
All right, thank you. And Mr. Williams, it's your opportunity if you want to say something. I know your attorney has said you do. I want you to understand you're not obligated to say anything. And I always make sure to let people know after they've gone to trial. I will not hold it against you if you don't, because obviously this will be part of the record for appellate purposes as well. So again, it's up to you whether you want to talk, but it is your turn if you want to.
Yes, I do.
Okay.
All right. Okay. I'm gonna go back to 2023 first, Mr. Miller. I stepped inside your courtroom and I took a plea of a stalking charge for me calling Mrs. Johnson, my wife, from the county jail phone because she had my money, my Social Security, to get me out. Okay, that's and they said that I was harassing and stalking from the county jail because I called her to get me out. I took that plea. You gave me that plea, I want to say maybe April the 24th or something, April the 15th, 24th or something like that, or 2023. I agreed to the terms of probation. From that time forward, I had Mr. Jason Jokoviak as my probation officer. From 2023 all the way up to 2024 until my probation officer.
Not really, Michael. It's not so much he's a good person. It's just everybody's against him.
Was switched, and I think my probation officer got switched like in August. We came in here, me, Mr. Jason Jokoviak, and Mr. Michaela, my public defender. We came in front of you right here in this courtroom in 2024 for a review hearing about me going to my classes for my sex case that I had, right? Okay. When we was right here in this courtroom, Mr. Miller, Mr. Jason, you asked Mr. Jason Jokoviak, how was I on probation? Mr. Jokoviak sit right here and told you in 2024, Mr. Williams does everything he's supposed to do on probation. He's never missed a day. He's always on time, and he does it. He's doing everything. Mrs. Johnson sit right here in this courtroom the same day and asked you to amend that statement order. You looked at me and told me that you was proud of me for doing everything that what I was supposed to be doing right here on probation, right here at this desk. Yeah, you said that if you finally seen a probation officer and a client that was getting along, that he was helping me get through everything of what I was supposed to do. Before that day was out, Mr. Miller, right here in this courtroom, Mrs. Johnson asked you to amend my stay away order because I had amended for me to come home because I had been at the shelter for 2 years and my kids needed me there and you wanted me there. She wanted me home. You asked Mr. Jacobiak, how did he feel about it? He told you Mr. Williams does everything. He's in compliance. He does everything he's supposed to do on probation. I do not have no problem with that, Mr. Miller. The only problem I have is every time Mrs. Johnson get mad at Mr. Williams, she calls the police and put him in jail. You look right at her and say, not if I meant it, that would not happen. He said, that's the only objection I have with Mr. Williams going on. Anything further than that, Mr. Williams is in compliance with everything that he's supposed to do right here in this courtroom. And you looked at me and you told me, you said, Mr. Williams, what I want you to do, you say, I want you to go do your evaluation because we had a thing about the time limit. You say my first probation officer put it in a day before that new statute came out and that I had to do it. I told you and I gave you my word that I would do it. You said, Mr. Williams, if you do it, then you don't have to come back the next following month. I said, okay, well, you don't have to worry about me coming back. No, Mr. Miller, because I'm going to do that. You said, okay. Mr. Jacobiak, see here and told you that he was going to be moving from being my probation officer. You told Mr. Miller that you didn't want him to leave from being my probation officer because you felt like Mr. Jacobiak, you told Mr. Jacobiak that you wouldn't want him to leave from being my probation officer because you see that he's helping people get through, and you never seen a client and a probation officer and a probation get through certain things of what he's getting through. And you told him that you would write a statement and everything for him to be there. He told you because of my charge, they was moving me to this new probation officer that I had. And you felt like it was going to be a problem. You thought it was going to be a problem. Okay, I went and did everything I supposed to be did for you. I did my evaluation and everything. I didn't have to come back. Then you told me that you would make a decision on me going home the next following on the first. But I didn't come in because you told me I didn't have to because I did my evaluation. So that never was planned. Okay, cool. I did.
I told you Monica was sweet. I told you.
We got the new PO. Me and him from I got to tell him the truth, Mr. I got to tell him from the first day forward, Mr. Miller, me and him had problems. He stepped on me like I was a nothing. And I never disrespected him. I did everything I was supposed to be doing, the same as I was doing with Mr. Jacobiak. He had a problem with me, I guess, being a offender, arrested offender. He stepped on me like it was like I was nothing. In 2 months, he was my PO. As soon as Mrs. Johnson called him on false charges, he violated me. He wasn't my probation officer for 2 months, and he's sitting here like talking about me like we had a big order. He wasn't my PO for 2 months out of 22 months. He stepped on me and belittled me from the day I walked in his office. He did not try to help me do that. I did. I paid for classes out of my pocket. He's saying that I got kicked out of the Gateway. Mr. Miller, no, I did not. I left it because I had a problem with a person that was there. I went to Diverses and I went to
thank you, Cosmic. Thank you.
The
so
place
much.
up on Union. I was telling you, the place up on Union, and started doing my classes. I paid for it out of my pocket. He told me for a month straight that they didn't have no vouchers. I paid for it out of my pocket. And I told her she could check the records and she could call up there. I paid for it. I told him I was leaving Diverses. Because why, Mr. Miller, when I went to evaluation, the first thing the lady in the evaluation class was his friend told me that I had to commit to a case that I don't feel comfortable with admitting to, then I have to plead guilty, basically. And that's what it was about. And she told me if I didn't admit, if I wasn't admitting guilty to what she was asking me to admit, then I was in the wrong and she kicked me out of the class. I told that probation officer over there that. I went to him and told him when he asked me, William, why haven't you been in class? I said, I've been calling trying to get in the class, sir. I sent him emails and everything up there. I said, she's not answering my call. I tried to purposely put myself back in class. Do you think he tried to help me, Mr. Miller? No, he didn't. He went on and violated me. He didn't try to help me. He violated me. After I sit in and I told him I was trying to get in contact with this lady in the classroom. Oh. Yeah. After he violated me. He didn't try to help me. Okay, and, but I have to tell him because I can't just let him not. Okay, so Mr. Miller, after in September, she filed false charges against me. The charges that I had initially, what he violated me on, all of them was dismissed. No charges at all. Not at all. I didn't even know nothing about these charges. Even when I called him and he said, Mr. Williams, I said, sir, how you doing? He said, Mr. Williams, have you ran into any law enforcement problems there? I said, no, sir. I said, the only problem I had was I was in a robbery, sir. He was like, well, I said, and I made police reports
No,
about
sir.
that.
No, sir. No law enforcement contact except for a robbery.
He said, well, you need to go and turn yourself in because I have, you've been harassing or, I said, sir, I don't even know who you're talking about. You know, and did I hang up the phone and spray Mr. Miller? Yes, I did, because I didn't know what he was talking about. You know, and he wouldn't explain to me who called.
I feel like he's harassing me right now because he won't stop talking.
Told him and where these accusations came from. Okay. Come around to February. Mr. Miller, was I in the house? Yes, I was. I most definitely was at my house. I've been living at my house. I can't even tell you no story, Mr. Miller. I've been there since day one. I helped move them in. She gets my Social Security check. She's over my check. I pay all the bills. I was there. You know, I was there. The day of that incident, Mr. Miller, she went through my phone. Every time I have been locked, this lady have put charges on me, and the state knows this. It has been by the phone. It's been by my phone. Am I a cheater? Yes, I'm a cheater. Yes, I'm a cheater. Is my wife goes off and does she do things that yes, she calls and put me in jail every time. Every time.
I agree with that. I like that. I like that arrangement. I wish that we had more of that kind of arrangement.
Every time I have been locked up, it has been by my phone. The first time in 2023, it was about my phone. First time in 2022, it was about my phone that she went and dropped the charges every time, Mr. Miller, sir. Every time. Now, as a man, am I standing here taking responsibility for what my actions was? Yes, I am. Did I violate my protection order by being in that house? Yes, I have. I've been saying this since day one. I have not took responsibility and accountability for my actions. But the state is sitting here allowing Mr. Johnson to violate me by putting false charges on me, humiliate me in front of the courts, humiliate the state, humiliate you, Mr. Miller, humiliate all of us at once, and everybody know this lady is nothing but a bald-faced, big-ass liar. Everybody can agree on that. Now, Mrs. Parker can agree on that. You can agree on that, Mr. Miller. You have right here and told me one day in court, Mr. Johnson made these statements, and that's the reason you're not going home, because she's a big liar. When you tell her, oh, I'm not going to move this out of court, she gets mad and she stumbles out of here, Mr. Miller. Have I had some problems in my past? Yes, I have. I'm not sitting right here saying I've been the best person in the world. But one thing I'm going to tell y'all right now, Mr. Miller, is that I never put my hands on Mrs. Johnson, that she's a big-ass liar. I know, yeah, she's that. And excuse my language, I don't mean to say that, but I'm just speaking from my feelings. Sorry about that. But she's a liar. She have lied on me most of the times of being here. The jury found me not guilty for no crime of violence. Every time I have left that house when that lady has put her hands on me, I always goes to jail. I always go to jail. Right now, my lawyer can show you statements where, and text messages, Miss Miller, where I told this lady to leave me alone. She gets mad every time I find another woman. She goes to the state, and now she's telling the state I'm threatening her and the kids. I have not threatened this lady not one time. I've been in jail 16 months. Play one call where I threatened this lady. Can't nobody do that. She continued to use the state as a hinge and to put me under. I'm a good guy. Have I had a bad past? I think everybody has. Had a past. But since I been here in Colorado Springs, Miss Johnson has put me in jail multiple times about my phone because I'm a cheater. It's never been me putting my hands on this lady physically. Never, ever. Never, ever. I never once did it. And everybody's looking at me like I'm a bad person. But they steadily letting this lady lie to all of us at once to get me put in jail. Now, am I here taking responsibility for what Mrs. Parker and them say a burglary is? I can't do nothing but take it because the way they broke it down, yes, I was not supposed to be in that house. Yes. But what about the lies that came with everything with me being right here? Don't do me like that as a person. I've been shot in my head. I've been shot in my head and 7 times.
Okay, case dismissed. Just shut him up. Hey, look, can you just shut him up?
Do I have anger issues? Yes, I think sometimes everybody might have anger issues. Some might handle deals a little different. But one thing I'm telling you to say, and I'm asking you guys, is not to go on me like I'm a violent person, because I'm not. I haven't done anything wrong, but the only thing I did wrong was not having permission to be in that house with you guys, and I'm wrong for that. And I'm standing right here as a man taking all accountability of it. But don't sentence me and break me down from lies. And again, and for the court, I want to say I'm sorry for knocking that damn bar off the thing. I have never had a burglary charge in my life, and for a woman that I take care of, that kids are not mine, and get found guilty of a house where I pay all the rent for, that the state they are continuing to put me in jail and take all of my money, my Social Security, everything, and put me in jail, and then I have to turn around and pay this lady what's called what did he say I had to pay? No, but what's the name of restitution for what? But I'm the one that's been assaulted, Mr. Miller. I try to leave, she threw bleach in my face. Scratches, beat me up, do everything. I walk away as a man, and people are looking at me like I'm a stone cold criminal for walking away. Every time I have been incarcerated for her calling, Mr. Miller, I have walked away from her, and she follows me like I'm a threat. And then she uses the state as a crutch not to let me out. Mrs. Parker, no, I'm not telling the story. She had disrespected Mrs. Parker multiple times and lied and everything. But as a man, I can't fault Mrs. Parker for standing here and giving me the definition of a burglary, but don't make me act like I'm a violent person, like I did something to Miss Johnson when I haven't done nothing, when I'm the one that's been violated and assaulted. You know? And I'm willing to stand right here, Mr. Miller, for 16 months. I'm standing right here willing to, you told me, Mr. Williams, you don't accept and you fight for what's right. And I tried to fight for what was right. I had the misconcept of what a burglary was. You know?
I don't fight for what's right, because what's right is different to most people. I do, however, fight for my right to party.
And when it was broke down to me, was I hurt? Yes, I was hurt. But I was more hurt because my wife lied and put me in jail. She lied and put me in jail. Not once, not twice, but 3 times. Even when Mr. Graspy was my lawyer, right there, he even told me to leave this lady alone. Am I in love with this lady? Yes, I'm in love with my wife, but I have never tried to harm her, nothing but take care of her and some kids that's not even mine. So, you know, Mr. Miller, I'm just asking you, as the judge that really has been in my life, that has really known the situation, what's going on, to sentence me to what do you think is right. And I want you to look at all the aspects of what I'm saying. And what I'm saying to you, you know it's true. It's true. Everything what I'm saying to you is true. I'm not sitting right here making up no lie, want nobody to feel sorry for me. Was I not supposed to be there?
Don't worry. The judge is going to tell you what he knows is true. Coming up real quick, buddy.
No, I was not. I wasn't supposed to be there without y'all, without the court's permission. And I'm here standing as a man. I've been standing right here as a court for 16 months. But everybody is going off my history like I'm a bad person. And since I've been in Colorado Springs, I haven't done a damn thing but get accused and been done wrong by a woman that I married that's using the peoples as a crutch here in Colorado Springs that can call and tell gibberish and in the police department file cases against innocent people. Right, and so I'm just asking you to look at all of that, Mr. Miller, sir, Judge Miller, sir, please, because I did what I was doing. I was supposed to be doing no probation, and this lady got mad at me and called the police and gave my probation officer false statements. That ain't now one of those cases in 2024 stood up over the grounds. And even when she told the prosecution of the cases in 25 in February, she still hasn't showed up and showed her face yet inside this courtroom and stood on what she said. Even in them phone calls. They have 1,000 phone calls over there where they didn't play, where she's admitting everything she's been saying. First they came in and told you I was a manipulator. Where did I manipulate this lady at to do anything, Mr. Miller? She walked in here in July and asked you to amend something because she said I was a great father and that the kids was missing me. I had nothing to do with nothing that this lady plans on doing. I think the whole court knows that. So I'm just saying, Mr. Miller, I just want you to look at all of that, like from where I started at, sir, please. Just look at all of that as accountability for me being a person of who I am. Do I have to own up responsibility for what happened? Yes, sir. And I'm standing right here, tall, earning responsibility. But what the state saying about 12?
Terry, are you still hanging in there with us? I didn't see Terry say goodbye. Did I miss it? If I missed it, goodbye, Terry. But I think you're still hanging in there with us.
I don't think I deserve 12 years for being in a household where I pay bills at, and a person lied on me, and have me standing right here in front of the courts today. I don't think I deserve that as a person. Do I need help from being shot in my head? Yes, sir. Hell yeah, most definitely. I've been shot 7 times. I suffer from TBI. I'm going blind in my left eye. I can't fight. I can't do nothing.
He was shot 7 times, different times in his life. Once in the head. Well, at least once in the head.
None of that. I can't do none of that. So for a person thinking that I'm a violent person, I can't. I've been shot in my head since 2010. I'm going blind. I can wake up in the morning and be dead for a blow in my head.
I'm gonna say, okay, I could be wrong, but I'm gonna push back on this one just a tiny bit. You cannot wake up tomorrow morning dead. You can do a lot of things with your life and don't let nobody hold you down. Do what you want to do. Except wake up tomorrow morning dead.
So my emotions runs high, and I'm sorry if the courts feel different, but my emotions runs high, and that's just the truth, you know. And I close at that, Mr. Miller, and I just ask you to judge me from that, you know, and from whatever I'm just look into that, sir, of what I'm telling you is all the way the truth.
Wait. Do you have a job that starts on Monday?
All right, thank you, sir. All right, guys. Well, obviously, everyone's aware I've had some case with Mr. Williams for quite some time. I certainly recall the incidents Mr. Williams is talking about in my courtroom. I recall some of them a little bit differently than he does, but that doesn't mean, well, I understand how he perceived things that way. I think your probation officer, I recall commending your probation officer for what a good job he did with you, sir. I think he was very good at sort of de-escalating the situation. I know you were in here, you were frustrated a number of times, and I was impressed with his ability to work with you, de-escalate the situation, and kind of get through to you. But I can't ignore kind of the long history. It's both good and bad, right? I know you're a very emotional person, and I don't hold that against you. That's not something I do in any case, right? I understand defendants are in here for very serious issues all the time, and whether they did it or not, they have a right to be frustrated. And so I never hold that against somebody. For the most part, you have been respectful of me in this courtroom, but you've not always been respectful in the courtroom, right? And you can be very angry at times. And that's different than passionate. I would say today at sentencing, you've been passionate, but you've gone past that sometimes too angry, right? And so I need to factor all these things in with respect to sentencing. I understand your argument, right? I understand both sides' arguments, quite frankly. I have a victim here, and she is a victim either way, right? There's a jury verdict. She is a victim. And again, to be clear, she didn't have any specific statement for you to read today. I mean, other than what you've already given me.
Not that she asked us to share.
Okay.
Yes.
All right. And so, Mr. Williams, I understand the frustration around that as well. And I've certainly seen her say different things that are not both true. Okay. And I understand your position that that's because she's lying. I understand the people's position that that's because it's the cycle of violence and domestic violence. What I do know is, again, I have a statement from her that I've referenced before. Stop letting him out of jail. He keeps getting out. He's dangerous. And then I have her come into my court and say, please let him out. Okay. And that can be because she's lying to me. And that can be because she's afraid of you, because this is a cycle of domestic violence. Okay. And so either of those things can be true. It's not necessarily both or specifically one or the other, right? Looking at the case, looking at the criminal history, the argument today, the pre-sentence investigation report, I have to come up with a sentence that's, the district attorney read the sentencing considerations, right? Factors in community safety, victim safety, rehabilitation, punishment. I have to put all those things together. That's the easy part, right? What's the right sentence? All those things. Figuring out how all those things come together into a number, that's the hard part, okay? Here's what we're going to do. In 25 CR 631, that's the trial case. That's obviously the controlling case. The high charge I have in that case is count 1, which based on the jury verdict, everybody agrees, and I don't know if I've said before, but I agree based on the jury verdict as well, that is an F4 burglary. Guys, I do need you guys to email Karen the statute number for the F4 burglary at some point, just so she can make sure that's accurately reflected. But I am sentencing you on an F4 burglary, Mr. Williams. And under the circumstances, the people are asking for essentially a 15-year sentence, right? 12 plus 3 on the stalking. You and your attorney have asked for a 4-year sentence. Probably not surprising to anybody. I don't necessarily think either of those extremes is appropriate in this case. On count 1, the F4 burglary, taking into account what happened here, the circumstances I'm aware of. And yes, Mr. Williams, I consider the burglary. It is a burglary, right? Fact, like you've said. But I consider what type of burglary it is too. Is this a burglary where somebody smashes a window, climbs in and commits a crime? Is this a burglary based on you living there and a violation of a protection order? And to be clear, it's an F4 burglary either way. But yes, I consider the facts of how we got there. On count 1, I think an 8-year sentence is the appropriate sentence given the history in this case. Count 3 is your other count that you are convicted of. That's the violation of a protection order. I will sentence you to 364 days jail to run concurrent to count one, the burglary. First off, guys, I think that's mandatory concurrent. And I guess my second question, what's everybody's position on whether that merges, since that's the basis of the burglary? I just thought of this, but I quite frankly think that merges.
And Judge, I'm going to leave it at I filed a motion regarding this issue before trial.
I know there's that, and that we had to sort out after trial. I do think that people can proceed.
They can merge it or they can run it concurrent. Either are the same thing and it doesn't matter.
On the burglary as charged, and I've made that ruling, and if I'm wrong, the appellate courts will fix that. But I actually think the conviction for VPO, since that's the basis of the burglary, needs to merge.
I believe that's correct as well, Your Honor.
Okay. So what I'm going to do is I'm going to vacate the conviction on count 3, guys, and find that merges into the burglary. So I'm not going to sentence to 364 days on that. I know. We'll make sure the mid is right. So in 25 CR 631, at this point, then there is only the one count 1 that I am sentencing you on, and that is to the 8 years in the Department of Corrections, followed by a 3-year period of mandatory parole. 23M433 is an M1 harassment revocation. I'm going to sentence you to 364 days in jail to run concurrent with 25 CR 631. In 23 CR 116.
And I had a case today where that gets a little harder. He just gave him a jail sentence to run concurrent with a DOC sentence. So I had a case today where they didn't know where the guy was going to go afterwards, because does he go to the jail and then finish out in DOC? That makes perfect sense to me. But they were saying DOC, then jail. It was confusing.
6-9, that is an M1 violation of protection order and an F5 stalking. I'm going to sentence you to 364 days in jail on that M1 violation of a protection order. On that F5 stalking, I am going to sentence you to 3 years in the Department of Corrections. That'll be followed by a 2-year period of mandatory parole. I am going to run those convictions concurrent with both of the other cases. So, Mr. Williams, the net effect in this case is an 8-year sentence. I think that takes into account the seriousness of the actions, as well as how the burglary came about in this case, and recognizes the criminal history. Mr. Williams, I do wish you luck in the Department of Corrections. I hope you do good time. I hope we do not see you back again, at least in my courtroom, when you get out. I will tell you, Mr. Williams, obviously this has been a hotly contested case from all sides. I think something that your attorney and the prosecutors and probation would agree on, and I'm going to agree with them as well. This relationship is not good for you, okay? And so it doesn't matter whether she's lying or this is a cycle of violence and you keep abusing her. This is not a good relationship. I would
also tell him that his future jail calls are going to be recorded, because I don't think he understands.
suggest to you that if you try and go back to this relationship when you get out, you're going to find yourself back here again, okay? And I'm not saying that's her fault. That can be your fault. But either way, I suggest you move on from that relationship, okay? I think that's your best chance of not coming back to see me again, at least as a defendant in my courtroom.
Yes, sir.
All right. Good luck, sir.
He got 8 years and he never laid a hand on her. He didn't harm her. He didn't hit her. He didn't punch her. He didn't kick her. He didn't push her. He didn't knock her down. He got 8 years for that. All right, listen. This next clip is a little bit vulgar. Yeah, I warned you. I just told you. The next clip is a little vulgar. I just have to find it. There we go. It's very short. Don't worry. Very short.
6 jurors who would sit in judgment on your case and decide whether the people had proven their case beyond a reasonable doubt. At that trial, you would have the right of confrontation. That means you have the right to subpoena witnesses. That means you have the right to cross-examine any witness who would appear and give testimony against you. You also have the right to subpoena witnesses to testify on your behalf. You have the right to proof beyond a reasonable doubt of every element of the charge against you.
Stop.
Please stop.
No, because it's a bunch of crap, and we all know it already. Well, this is already the 34th time I've been arrested under 7 fucking charges every time. I'm example, and I'm.
Ma'am, I need to mute you so I can get through the advisement. Ms. Martinez, you're still on mute. You have the right to a unanimous verdict. That means that all of the jurors must agree that you're guilty beyond a reasonable doubt. At trial, you can testify or not testify. Whether you testify is always your decision. It's never your attorney's decision, the DA's decision, or the court's decision. You have the right to appeal any verdict to a higher court. If you do testify, you can be cross-examined about the case. You can be cross-examined about the nature of the charges. And if you've been previously convicted of any felony, the people could disclose that prior felony to the jury. Ma'am, you can sign up for text reminders to go to court if you bond out in this case. Mr. Bullock,
So you remember, I don't know if anybody's going to remember. Hi, Christopher. Chris. Hi, Christopher. Yo, I cannot remember her name. I haven't checked in a long time. But Judge Khan, there was that lady, Miss... See, and I know it started with an M, but I really don't think it was Miss Martinez. But doesn't she really, really, really reminds me of her a lot. And her last name starts with an M, and this is Colorado. But this is Otero County, Colorado. The woman that we've been following for like 2 years, she's in Denver. She's 100% in Boulder. I don't know how close Otero is to Boulder, and I can't see her close enough to see if that's her. It could possibly, there's a more than 0% chance that is her. Remember, she was going to move to Texas, and her father left her a house, and every time she showed up to outdoor court, remember outdoor court, they took off like 2 more of her charges. She had like 13 left the last time we were talking to her. She had to sign the papers for all these different programs to get her personal information, and she wouldn't sign. And she kept hitting on the prosecutor. Christopher, hi, Christopher. Do you remember her? Anyway, that could be her.
you need to set bond in Ms. Martinez's case. I'd hear recommendations from the people.
Judge, I believe that Judge Ehring has set a bond previously in the amount of $750 cash or surety, and I believe that bond would be the appropriate bond in this, continuing in this manner. I just asked the court to adopt that.
All right. Ms. Martinez, you don't have to, but do you wish to make any statement concerning bond in this case?
No, how much would you say?
It's $750 is what it's set at right now, cash or surety.
And then I could get out?
Yes.
Okay.
All right. Mr. Bullock, I also need to issue.
So that sounds like it's her voice, but she's not hitting on the judge. She's not telling the judge how beautiful his glasses look. And you remember how animated she was and walking around. Look at her sitting there. Now, she could be heavily medicated. I don't know.
A protection order in this case?
Judge, I would request that the standard provisions for the protection order entered. I would also ask, I don't have the information, but my office can certainly provide it to the court, the victim, that there be no contact with the victim in this case.
All right, that'll be the order of the court. Ms. Martinez, I'll order that you shall not. It's Tara Starks. So you're to have no contact of any kind with Tara Starks. You shall not harass, molest, intimidate, retaliate against, or tamper with any victim or witness to the crimes you are alleged to have committed. And you're to have no contact of any kind with Tara Starks. Do you understand, ma'am?
Oh yeah, that's a promise that I won't. Fucking
Okay,
little lesbian, molesting bitch. She's a fucking rapist and abuser. She abuses babies, infant babies. Sick ass cunt.
All right. Well, I'm putting you on mute again. I just really want you to acknowledge that you understand the protection order, and thank you for doing that.
Well,
If
I
you
want
violate,
one against her too. I actually want to press charges against her as well. She got me sick. She's a little sick lesbian bitch, and she was breaking into my apartment, and that's why she got hit.
all right, well, I don't have the power to grant a protection order for you in that case, in that matter right now. So here's what we've done. I've issued a protection order. You have a bond of $750 cash or surety to get out. Your next court date will be May the 18th at 8:30 in front of this court in Division 1, Carroll County Court. Now, Ms. Martinez, I was the DA on a lot of your old cases. So if you want to have a different judge, that's fine by me. That doesn't hurt my feelings.
Yeah, I don't think it's hard.
If you'd rather have a judge that was not a DA on your cases, you just need to let me know that and we'll make sure we get a special judge appointed, okay?
Okay.
So you need to be back here May the 18th at 8:30, all right, ma'am?
All right.
Okay.
All right, thank you.
Our last one is not vulgar in any way.
I hope we get better.
Okay, thank you. I appreciate that.
See, I hope you get better. It could be her. There's a bigger than 0% chance that was her. I just don't know. So this last one is crazy. Here we go. We're just hearing the jury verdict. That's all we're hearing in this last one.
The verdicts that are completed appear to be in order. Jury verdict, assault in the third degree. We, the jury, find the defendant, Aaron Jenkins, not guilty of assault in the third degree knowingly and the lesser included offense of assault in the third degree recklessly. Jury verdict, child abuse, Spencer Masters. We, the jury, find the defendant, Aaron Jenkins, not guilty of child abuse. Jury verdict, child abuse, Crystal Jenkins. We, the jury, find the defendant, Aaron Jenkins, not guilty of child abuse. Jury verdict, child abuse, Christine Jenkins. We, the jury, find the defendant, Aaron Jenkins, not guilty of child abuse. Jury verdict, criminal mischief. We, the jury, find the defendant, Aaron Jenkins, not guilty of criminal mischief. The verdict form for obstructing a peace officer is unsigned and not completed. Any request to poll the jury, Mr. Sullivan?
No, Your Honor.
Ms. Banducci?
No, thank you.
Judgments of acquittal will enter as to those counts. The court declares a mistrial as to the obstructing a peace officer count. I never remember to pull up the mandatory discharge instruction, ladies and gentlemen, when I should, but let me just find it here. Ladies and gentlemen of the jury, you have now completed your duties as jurors in this case and are discharged with the thanks of the court. The question may arise whether you may now discuss this case with the lawyers, the defendant, or other persons involved in the case. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk with them, but you need not. If you talk to them, you may tell them as much or as little as you like about your deliberations or the facts that influenced your decision. If any person persists in discussing the case over your objection or becomes critical of your service either before or after any discussion has begun, please report it to me. I don't anticipate that will occur, but if it does, report it immediately. I have a few legal matters that I need to address here in the courtroom, but I'm always happy to come back and chat with you all if you'd like to hang around, but you're not required to do so. I understand that some of you may wish to speak with the attorneys as well. They have a few things that we need to address here in the courtroom. Ms. Felix, you're welcome to join the jurors back in the jury deliberation room to discuss anything that you wish. All please rise for the jury.
So they were some hefty charges this person was just found not guilty of in a jury trial. Child abuse, hefty, bad charges, not guilty. Well, obstruction, I think, was the last charge. Obstructing a police officer. So probably when the officer came to arrest them, they resisted or something. I don't know. The jury forgot to sign that paper. They didn't sign the verdict, so mistrial. Now, they're going to explain it better.
Did Mr. Sullivan, are the people in a position to determine how they'd wish to proceed at this stage?
No, Your Honor.
Would you like me to reset a trial?
I think we can reset a trial for now, and then we'll determine if we're going to do anything else.
Another trial.
Other than that.
It's 90 days, I think. Is that correct?
90 days.
Speedy trial deadline is August 12th, 2026. Mr. Sullivan, how long do you think that you might need for a trial?
I think 2 days, maybe even one, but let's do 2.
Ms. Banducci?
I would say at least 2 days.
Anything else that I need to address today? Mr. Sullivan?
No.
Ms. Banducci?
And I would just ask to modify Mr. Hold on a second first. Just asked to modify Mr. Jenkins' bond. He's on a PR bond. He's had pretrial supervision the entire time he's been on bond, which has been a year and a half. Given the verdicts today, the only remaining potential count being a class 2 misdemeanor obstruction, I would ask to remove pretrial supervision as a condition of bond.
Mr. Sullivan?
I think pretrial supervision is still an appropriate condition of bond, especially because there have been pretrial supervision violations by Mr. Jenkins.
Come on, it's a misdemeanor. It's all you have left is a misdemeanor, and he's already been on probation for well over a year. So you have nothing. It's going to be time served, if anything, unless you dismiss it.
While on bond, I think just one, but it involved nine missed tests and 2 positive tests. So I do think that the pretrial supervision is appropriate.
No, it's not.
I'm going to modify bond to relieve Mr. Jenkins the obligation to continue to report to pretrial services given the acquittals in this case as well as the only remaining count. Mr. Jenkins, you're otherwise required to continue on that personal recognizance bond, but I'm vacating then the prior conditions. It'll just be a straight PR bond. You need to show up for court. Okay. And but mandatory conditions: don't commit new crimes. Don't leave the state without signing a extradition waiver, etc. I'll see everybody back here July 9th at 9 o'clock for a readiness conference. I think the jurors wanted to talk to the attorneys.
Okay.
If you want to hang out, I'll go back there and chat with them first, and then I'll have Miss.
Oof. Yo, we got so lucky there. Lucky. I didn't see the trial. I don't want to see the trial. I don't really do child abuse trials here. We don't go down those roads. Every once in a while we get close, but we don't really go that far. All right, guys. Thank you so much for coming out. I really appreciate it. I'll see a bunch of you in about 6 hours. I hope that you have a great night. Thank you so much, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.